here.
Okay, fine.
Okay?
I know there's plenty of place to put papers, good.
Exactly. And this gentleman should be the one taking care of things.
Lovely.
Let
and
me-
I think I'm a bit too long. Is that all right? I have a captive audience. They can't get up and walk out.
Ladies and gentlemen, would you like to start getting seated so that we may proceed? Ladies and gentlemen, dear guests, good morning, and you are very welcome. This is the beginning of a very, very, very long process, but I must say that I'm extremely pleased, happy, and honored to welcome you here in this magnificent hall of the National and Capodistrian University of Athens. We expect to have you around for the next 4 days. We hope that the discussions we're going to have are certainly less heated than the atmosphere all around. If you haven't noticed, it's hot. So we'll try and make the best we can. But this is summer, and this is summer in a time of climate change. So please bear with us to the extent possible. We are going to be quite a number over the week, almost 400 people. And I would like to thank you very, very much for this response to our invitation to come over to Athens and celebrate with us the first Congress, the first conference of the International Law Association after the magnificent celebrations for the 150th anniversary in Paris last year. So, without further ado, let me call upon the president of the organization, Professor Manuel Almeida de Ribeiro, to kick off the proceedings. Manuel.
Good morning, everyone. Just a few words to welcome all of you. I think that Maria, with more authority to do so, has just did it. I think that is a pleasure for all of us being here in the cradle of democracy and Western philosophy. I hope that we all have 4 fantastic days here in Athens. And now I call our dear chair, Professor Chinkin, to take the floor. Thank you very much.
So I'll add my good mornings to everybody here. It is great to see so many of you. And I'd also like to record good morning and welcome to those who are going to be joining online at some point during the conference this week. It's a great privilege, of course, to be participating in this opening ceremony for the ILA's 81st Biennial Conference here in, as Maria just said, this magnificent room and in the shadow of the magnificent monuments of Athens. I think many of us at breakfast sat there thinking, what a view out of that window as we ate our breakfast. So the first thing I should do is express my warmest gratitude to the Hellenic branch and especially to Professor Maria Gavunelli, Maria, down here, for the enormous amount of work that she's put. She and the officers of the Hellenic branch and the organising committee have all put into preparing this conference and for the welcome that we have received and no doubt for the many pleasures during the week that are coming. As I'm sure pretty well everybody in this room knows, the ILA is a federal association operating through its regional branches that have now been established across all the continents, except Antarctica. The autonomous branches are, of course, the lifeblood of the association. Each has its own constitution, its own membership, organises its own activities, operating under the umbrella of the association. And one of the pleasures of my position is getting to know the different branches rather better through the biennial conferences and through various other activities. And so our hosts this week, the Hellenic branch or the Greek branch, is simultaneously one of the oldest branches of the association and in its current form one of the comparatively more recent. It was first established back in 1911 and then it was re-established in its present form in 1998. I'm sure there's a backstory there that I hope somebody will enlighten me to at some point. The Greek branch website also explains that branch members, academics, lawyers, practitioners, students, share, to quote, a common passion in contributing to the development of international law and raising public awareness. And it's clear from the many events undertaken by the branch that they take this seriously. There are branch members participating in the committees and the study groups, there are branch conferences, there are academic publications, and in 2013 there was a highly successful regional conference entitled Imperium Juris Governance Trade Resources. And of course now the branch is adding the 81st Biennial Conference. I think we're still sufficiently close to the COVID-19 pandemic and the lockdown to appreciate that we are, as we were in Lisbon 2 years ago, once again able to meet in person. But I might just also note that the pandemic has caused some changes to the association that have been positive for an association with the global reach of the ILA. So one of the 2 annual executive meetings is now held through Zoom. And while this lacks the immediacy and the warmth of in-person meetings, it does have the significant advantage of wider participation, more diverse participation, and, of course, less of a burden on individuals travelling to London and less of a burden, therefore, also on branch finances. There have been challenges. The time difference, of course, is obviously one of them, with some stalwart Executive Council members participating either very late at night or very early in the morning. And I truly commend and thank them for their effort in doing this. And I also thank the Greek branch for taking the step to make this the first hybrid conference, again allowing for more inclusive participation. And while I am thanking people, I'd like to express my extreme gratitude to a number of other people for their commitment to the association and the time and expertise they bring to it and the personal support they have given me. And I think that includes all members who are here today. But then further, the officers and the management committee, and of course Claire Martin and Renata Wardle for their continued hard work on so many fronts, keeping so many different balls up in the air at the same time. The association would simply grind to a halt without their commitment, hard work and effort. This conference also sees the group of ILA scholars, which has now become a feature of the biennial conferences. There are 6 scholars here. They've been selected from a list of very high-quality applicants, 5 women and 1 man. They come from 6 countries across 4 countries, And I especially thank our patron, Bruce Malevera, and his team for the hard work they have done in selecting the scholars and making this programme an important, significant, vibrant part of the association and of the conference. The scholars will make their own reports on the conference. I hope we will hear from one of them at the closing ceremony. And in the meantime, please try and meet them, make them welcome, and welcome their joining the ILA and also the community of international lawyers. And then there are two people who this year I need to make it a special expression of gratitude. The first is our Vice Chair, Catherine Kesedian, who with the French branch worked tirelessly to ensure the association marked in style its 150th anniversary last year. The celebrations were year-long. They comprised an innovative programme of white papers touching upon the burning issues of international law today, webinars where expert speakers subjected the white papers to critical discussion, raising not only the issues of the white papers themselves, but extending far beyond it, the splendid conference in Paris a year ago, and then a final day in December which was devoted to 4 overall and cross-cutting themes: creation of international norms, by whom and for whom, creation of international norms, which norms, effectiveness of international legal norms, and dispute resolution. And there's also been 2 publications that have come from the anniversary celebrations. The first is entitled To the Benefit of International Law. It was launched at the Paris Symposium last year, and it comprises essays on the state of the world and the state of international law in 1873, the year of the founding of the association, histories of a number of branches, and accounts of the influence the work of the ILA has had on the development and progression of international law. It has a sort of kaleidoscopic effect, which makes it a fascinating book to dip into and learn details about the reach and impact of the ILA and of the different branches. The second book was published just a couple of weeks ago. It's called Build Tomorrow. It brings together the accumulated knowledge of the white papers that were produced throughout 2023. It synthesizes them into conclusions and recommendations. In fact, it's a blueprint for thinking about the future of international law and of the association. To quote from the foreword of the book, it offers a formidable harvest of ideas and proposals, all of which are incentives for action. And so we are at headquarters are thinking particularly, how can we act? How can we take up these incentives? How can we make this central to our substantive thinking and to ensure that it doesn't become just another book on the bookcase or these days online? It could be a living testament to the association moving forward. And if people have got suggestions as to how this could be taken up within branches, for example, please let us know. And Catherine and the French branch deserve our sincerest admiration and congratulations for the work they put. Yeah. For the work that they put into making a tribute to the past history of the ILA while providing a true programme for the reform and development of international law. And the second person I want to express my gratitude to is another member of the French branch, and that, of course, is Pierre. Pierre Baudot-Livnec, who's completing his term of Director of Studies at this conference, having graciously agreed to stay on beyond his resignation to see this conference through, for which I truly thank you, Pierre. I think we don't always remember just what a burden of enormous responsibility in keeping the association to its objective of promoting the progressive development of international law the Director of Studies undertakes. He oversees the launch of new committees and study groups, ensures the workability and feasibility of mandates, that the proposed topics of study are relevant, forward-looking, ensure that they are in areas where the association can make a valuable contribution to its objectives. and that there's overall a reasonable balance between public and private international law. The DOS then also helps committees in many ways through their lifetime, and finally ensuring the committee's final report and recommendations are properly worked through, capture the significance of the work. As there are generally somewhere in the region of about 20 committees and study groups at any one time, this is a formidable workload. And the Director of Studies carries most, if not all, of this work single-handedly. So, Pierre, thank you very much indeed. I would like to add that he tells me he can be grumpy. I've never yet actually come across that, as he's carried it out with great good humour and in exemplary fashion. And I think is handing over the substantive work of the ILA in very good shape, with new committees, well-established committees continuing very well. And, of course, he also carried out an intensive study into the process and procedures of committees and study groups. He made some sensible and frankly overdue recommendations. This work has been in a way stalled at this point because he very wisely decided that this was not the appropriate moment to carry out such reforms with, of course, a new Director of Studies coming into place. But I'm sure that the quality and effort that you have put into this will still continue to shape the work of the Director of Studies for some time to come. And of course, Pierre's departure as Director of Studies means a welcome to Professor Lukas Lisinski, who's also here. He's here this week essentially to learn from Pierre and at this particular conference, and then with the formal endorsement of the formal endorsement by the full Council at the end of the week, will take over the role of Director of Studies. And so we wish him well with his future work. Okay, to turn... I'd like to turn now to more the substantive part of this conference. The subject of this 81st Biennial Conference is International Law in a Fluid World. And the online address reminds us that international law, like any form of legal ordering, cannot be static, cannot be set in stone like a statue or monument, but must be fluid, evolve and move forward. But this movement does not necessarily denote linear progression. And in any case, as the organisers also ask in their note, what does moving forward mean? Is it expanding and progressing towards a liberal ideal? Or is it shrinking in front of what often appear to be the insurmountable challenges and crises that are currently undermining the international legal order and the international rule of law? Or is it today simply hanging on to what we have already gained, advances that we had thought to be entrenched? The conference programme highlights a number of areas where these questions are especially pertinent, and speakers throughout the conference will explore those themes from their own different perspectives and within different subject areas. I'm looking forward to hearing a range of views, but what I'll just do very briefly is make some of my own reflections. The geopolitical fluidity of the contemporary world has resounded on international law in numerous and often unanticipated ways. Around 2 decades, perhaps longer ago, there was concern that the greatly expanded scope of international law that was occurring in the wake of the great changes of the early 1990s and of globalization had led to the emergence of multiple specialized regimes, each with their own internal methodologies, concepts, and language, in effect creating a number of legal silos and undermining the coherence of the legal order. But our understanding of international law is also fluid. Legal historians have exposed how that apparently coherent legal order was founded upon colonialism and racism. It served the interests of the powerful, who thus have that interest in preserving the status quo. But as these regimes proliferated, as demands were made for international legal regulation by an ever-growing range of different actors, boundaries between these silos, between the regimes of substantive law and their supporting institutional frameworks, has come under ever greater pressure and even collapsed. Fluidity denotes an end to clear demarcations, such as those between disciplines, between institutional mandates, between areas of law. There are numerous examples that we can look at over the last few years, decades. To take some from my own areas of law, the declaration at the Vienna Conference of Human Rights in 1993 that sexual violence and armed conflict violates both international humanitarian law and international human rights law signalled an end to any clear boundary distinction between the laws of war and human rights law, as does the setting up of commissions of inquiry by the United Nations Human Rights Council to investigate simultaneously violations of international humanitarian law and of human rights law. The Yugoslav tribunal that had to determine the legal implications of the so-called new wars of the 1990s oversaw the weakening of the distinction between an international armed conflict and a non-international armed conflict. The ICC, International Criminal Court, itself created at the behest of civil society and in the face of opposition from powerful states, is required to apply and interpret international criminal law consistently with human rights law and without any adverse distinction founded on grounds such as gender. This last perhaps provides a powerful illustration of the implications of recognizing fluidity and the associated disruption of long-accepted definitional boundary-created binaries. In 1998, the Rome Statute defined gender as, to quote, the two sexes, male and female, within the context of society. When the International Law Commission replicated this definition in its draft articles on crimes against humanity, it drew many protests from civil society and from states that it was outdated. It was in its failure to reflect the gender and sexual identities of many people, thereby highlighting the need for international law to accommodate social fluidity. The inclusion of individuals as the holder of rights of obligations under international law, of course, marked what to many was a seismic fluidity change in international law some decades ago, an inroad into the state-based system of international law. In the early 1990s, the concept of gender had barely entered international discourse, but the debate following the ILC's draft and inclusion of that definition indicated that it was moving forward, and further, the need for the law to encompass such intersecting and individual identities. The ILC has withdrawn that definition. It hasn't proffered an alternative. And meanwhile, debate swirls around other new concepts, for instance, gender persecution, gender apartheid. What might their inclusion imply for international law? Realization that insistence on the gender binary creates gaps in the efficacy of protection under international law, in turn challenges other binaries sustained by international law. I'm sure you can all name many of them: victor, perpetrator, civilized, non-civilized, conflict, post-conflict, legal war, illegal war, self-defense, aggression, state, non-state, accountability, impunity. None of these legal formulations are static or stable. All are clearly relevant as to how we understand and apply international law today, including current events such as ongoing conflicts, such as those in Ukraine or Gaza Strip or in Sudan and elsewhere. And we also have to look to the fluidity of international institutions. The Security Council, the body mandated with the responsibility for the maintenance of international peace and security, has in some ways erased the boundary between national and international security and human security, recognizing that issues such as human rights, social justice, public health, sexual and gender-based violence come within its remit. but it has at the same time failed to fulfill its primary responsibility through the paralysis bestowed by the veto. So on the one hand, states have challenged its mandate to address such wider issues. On the other hand, the baton has perhaps passed more to the General Assembly, the body that has taken it upon itself to denounce aggression in Ukraine, to demand immediate humanitarian ceasefire in Gaza, and to determine that the state of Palestine is qualified for membership in the United Nations. And the ICJ, the International Court of Justice, too, has shown itself willing to respond to changing circumstances. For instance, by accepting the repeated applications from South Africa in its request for provisional measures against Israel and modifying its orders in light of the change in situation that justifies such revocation or modification of earlier orders, in the words of the rules of the ICJ. Another example of the court giving effect to the fluidity and overlapping nature of international and national law is its finding of admissibility in the case brought by the Gambia against Myanmar. In recalling its 1951 description of the objective of the Genocide Convention as, to quote, on the one hand to safeguard the very existence of certain human groups, and on the other to confirm and endorse the most elementary principles of morality, the court confirmed that, again to quote, in such a convention, the contracting states do not have any interests of their own. They merely have, one and all, a common interest. Consequently, one cannot speak of individual advantages or disadvantages, or of the maintenance of a perfect contractual balance between rights and duties. The high ideals which inspired the Convention provide, by virtue of the common will of the parties, the foundation and measure of all its provisions. The concept of obligations owed erga omnes that flows from this, and of course was incorporated much earlier, collapses state boundaries and procedural boundaries in its recognition of the common interest in compliance. I think this is further demonstrated by the record number of states participating in the request for an advisory opinion with respect to the legal consequences of the occupation of Palestinian territory. And if the court accepts the request to intervene by Palestine in the South Africa case, it will represent a further move allowing the so-called real applicant to appear before the court, something that was not possible back in the 1990s, for instance, in the case of East Timor. But I think all of this indicates another shift, further fluidity. Our discipline, international law, both legitimizes violence, for instance, through principles that uphold the violence of colonialism, the laws of war that assume violence through the claim of military necessity, all allow for considerable legal violence. But it is also, and simultaneously, a tool of resistance. Its fragmentation, its fluidity, can provide an instrumentality for the challenge of oppressive power. So we see this strikingly being relied upon to boost the position of those who are otherwise without power. For example, by the Gambia, by South Africa, by Nicaragua, through commencing their proceedings at the International Court of Justice. And it is also striking that it is countries from the global south, those that themselves have suffered through the Eurocentric legal system, that are now using international law to challenge those who see themselves as the very denizens of international law. And in so doing, they are exposing the hypocrisy of the latter in appealing to international law when it suits them, while deliberately misinterpreting and misapplying it to advance their own interest or those of their allies. Ignoring the double standards that they therefore exhibit, and when necessary, even denying its applicability. Far from celebrating fluidity, they reassert the legal silos and tighten their physical boundaries against those who are displaced. In so doing, they undermine their own assertion of an inclusive rule of law, but also create space for its applicability as a tool of resistance by those previously oppressed. We are currently witnessing international law being trashed before our very eyes through the assault, including by Western liberal democracies, on the post-World War II legal architecture and norms, the primary ambition of which is to save succeeding generations from the scourge of war. But we are concurrently witnessing the reclaiming of international law, affected through its political and judicial institutions, by those whose freedom and liberty from colonialist oppression were secured at least in part by the norms and mechanisms of international law. They are turning to law, recognizing its continued value and potential, notwithstanding its origins in empire. Law's institutional structures are the sites they are turning to for reimagining, reshaping, looking for a new international law. As an association committed to the promotion of international law, we should, I would say must, uphold and support initiatives that call for its application as a tool for justice, for racialized, colonial, gender justice against those who ignore or flout international law today. We are admittedly working against a very threatening backdrop of silencing of critique. Intellectual bodies are pushed back and championed into their silos. Debate is narrowed and divorced from context. And this is what makes the work of the ILA just so important, the detailed analysis of international law within the various contexts in which it arises and which makes the work from the 150th anniversary just so important. At this moment of deep political fissure, maybe law and its institutional mechanisms can provide some strength, some cohesion as a tool for resistance. So, thank you. As many of you know, we might have been holding this conference in Delphi. We're not holding it in Delphi, we're here in Athens, but what we do have is oracles. And so I will now turn to our first oracle, who again I think needs no introduction, but we're very honoured to have His Excellency Judge Yuji Iwasawa here today with us. Judge Iwasawa, Yuji, is of course a judge of the International Court of Justice, a former member of the UN Human Rights Committee and the ILA Committee on Human Rights, and of course, most importantly, a Vice Chair of the International Law Association. So, Yuji.
Excellencies, ladies and gentlemen, and thank you very much, Christine, for your introduction. I was asked to give a few words as a senior member of the ILA several days ago. So this is not meant to be a keynote address or anything of that kind. I just give a few words as a senior member of the ILA. I'm very pleased to be back in Athens. Every time I come here, I admire the rich history and civilization of Greece. It is really incredible and remarkable that the Greek people had such sophisticated civilization in the 8th century BC. I came to Athens for the first time in 1986, 38 years ago, with my wife, who is sitting here. I was on my way back to Japan for my graduate work, PhD work at the University of Virginia. We decided to go back to Japan eastward through Europe. So I came to Athens in August 1986. It was a very hot day, and my wife and I were waiting for a taxi in a queue at the airport. And there was an elderly Greek couple in front of us, and they were having orange juice. And my wife and I were very thirsty, and we were enviously looking at them, drinking nice cold orange juice. And they noticed, they turned around, and to our surprise, they offered us the cold orange juice. And we were engaged in a nice conversation until our turn for a taxi came. And then before they left, they gave their address, and they suggested we visit them. So we did, and we visited their house in Athens, and the wife of the elderly couple showed us their house and then took us to a restaurant nearby. And the lady who was called, whose nickname was Poppy, she was very popular in the neighborhood. She knew everybody in the neighborhood. Everybody said hello to her, and she said hello to everybody, and on the way to the restaurant. And we had a nice dinner, but we realized that they were having such a nice life, which we don't see in Japan. And we really had a nice time at their house, and we became very close. So after we were back in Japan, we sent Christmas cards to them, and we kept sending Christmas cards to them. So we have kept contacts for a long time. And Poppy, who didn't speak good English, but once called us in Japan and suggested we visit them again to see Olympics, but we couldn't. And then in 2016, when I was having sabbatical in Paris, Professor Pasaltis, who is sitting here, who was my colleague on the Humorous Committee under the ICCPR, invited me to give a lecture at the University of Athens. So my wife and I came to Athens. The purpose of the visit was to give a lecture at the university, but Professor Pasaltis took us to the house of Poppy, and we could see Poppy again after 30 years. Unfortunately, her husband had passed away, but we had a nice time with Poppy. We saw her again, and it was very, very good to see her again. And to our surprise, that she kept all our Christmas cards and photos in a drawer, and the drawer was labeled the Japanese family. We were very happy to see that, and we had a nice time. But Poppy passed away next year, and it was that good that we could see her again in time. Now, I came to Athens on my way back to Japan, but before reaching Japan, I stopped in Seoul, Korea, to attend ILA conference in 1986. I was in the early 30s, and I really enjoyed the conference very much. But this was not the first conference for me, ILA conference that I attended. The first conference, ILA conference that I attended was one in Manila in 1978, 46 years ago already. I was in the mid-20s, I was a young academic, and from my early days, I was interested in the work of the ILA, and I was finishing my LLM at Harvard Law School, and I heard about this conference in the Manila ILA conference, and I wanted to attend the conference. So I decided to stop in Manila before going back to Japan. So that was my first conference. And I was a very young academic in the 20s, and I was very excited to see many people whose name I knew, and whose books and articles I had read. And it was really exciting for a young academic to attend that this was the first international conference for me. So I remember this first ILA conference very, very well. Now, the third conference I attended was the one in Cairo in 1982. I was having a sabbatical in Cambridge, and I went to Cairo from Cambridge. And James Crawford was the director of studies, and he asked me to join a committee to help the director of studies. I was young, I was in the late 30s, but still, I mean, James knew me well, so he asked me to join the committee. The ILA didn't have a standing committee yet at the time, but James came up with the idea to form a committee to help the director of studies already in those days. So he asked me to join, and I joined, and we tried to help the director of studies during the conference. So that was my third conference. Then in the mid-90s, I was asked to become a rapporteur of a committee. Professor Richard Lillick, who was my supervisor at the University of Virginia, was the chairperson of the International Human Rights Law Committee of the ILA. So he asked me to become a rapporteur of the committee, and I agreed. So I attended the Helsinki conference in 1996. But Professor Lillick died just before Helsinki conference. And ILA appointed another co-rapporteur, Professor Andrew Burns. I'm sure he's somewhere in the audience. And also another new chairperson, Martin Scheinin. And we basically had to run the committee without Professor Lillick. So I served as a committee officer for the next nearly 20 years in the Human Rights Committee, together with other co-rapporteur and the chairperson. So that's how I was involved in the work of the ILA. And then I was elected as a vice chair of the ILA in 2016. So I have attended all International Law Association conferences since 1996 without missing any one of them. So I have attended 16 conferences in a row until this time. So together with the 3 conferences before, this is the 18th conference that I'm attending. And I am getting a lot of reward from attending conferences and my involvement with the ILA. In the meantime, when I was in Cambridge, I was also asked to join a committee on the future of ILA. I was in the late 30s, I was a young academic, but I think ILA wanted diversity in the committee. I was a young academic, and Japan branch was a big branch from Asia, and I happened to be in Cambridge. And I worked with Professor Soons, who is there, to compile a report for the ILA on the future of the ILA. So that's another involvement that I had with the ILA. And so overall, I have been involved in the ILA in many different ways, and my involvement with ILA has been very, very rewarding, and I have learned a lot from all the ILA conferences. The theme of the conference in Athens is International Law in a Fluid World. I think this is a very timely topic, as our chair, Professor Chinking, explained eloquently. I think international law has a very important role to play to address the challenges created by this fluidity of the world. And I'm sure that the conference will be a very, very successful one. Since I was involved in the committee for nearly 20 years, I know how important the work of the committee. The ILA it's based on the work of various committees. And I hope that you will learn a lot from the work of various committees in the ILA. And also the organizing committee of this conference has organized nice, interesting parallel programs. So I hope that all of you will enjoy not only the committee sessions, but also parallel programs organized by the Hellenic branch. In addition, I think an important part of the ILA conferences is networking. Through the 18 conferences that I have attended, I met many, many friends, new friends, and I also have renewed friendship with old friends. And the friendship I have created and built through these ILA activities is my big asset. So I hope that you will take this opportunity and make much of this opportunity and enjoy this wonderful conference in Athens. Thank you very much.
I would like to thank Judge Iwasawa, dear Eugene, for these words. I think that the title could easily be A Life in International Law, which could also be A Life in International Law Association. So those two go together. But I think that we have already indicated how important it is, the work of the various committees and study groups for the life of the organization, but also for the development of international law. So who better to walk us through that than our own Director of Studies, Pierre Baudot-Livinec. Please.
Monsieur le Président Manuel Almeida Ribeiro, Madame la Présidente Christine Chinkin, Madame la Professeure Maria Gavunelli, chers collègues, Mesdames et Messieurs. International law in a fluid world, le droit international dans un monde en mouvement, is the general theme of our conference. By definition, the law is always fluid, in the sense, at least, that it must constantly adapt to emerging needs and challenges. Ubi societas ibi ius, in that sense, is not a standing honor, but a commitment to legal dynamics under social pressure. I'm not sure that our world could be aptly described as being currently fluid. It rather seems constrained in a narrow corridor between a rock and a hard place. Finding the path of progress and human dignity within the walls of exacerbated nationalism and blind capitalism is not an easy task. In such a context, challenges for international law and for international lawyers are high and somehow paradoxical. On the one hand, we must firmly preserve the pillars of our common house, and at the same time, we must patiently pave the way for a true rule of law-based international order. While it is my sincere hope that the 81st ILA Biennial Conference here in Athens will contribute at its modest level to this important endeavor, in that respect, I'm very happy to note that all 20 existing committees and study groups will hold open sessions, by which I mean meetings available to all participants at the conference between now and Friday. For the sake of time, I will not go into the details of the program, which is available on the website of the conference. I will only emphasize that once again we will cover very significant issues of public, private international law and transnational law. If I limit myself to those committees proposing draft resolutions to our attention, and for most of them finalizing their mandate, those are the Committee on Human Rights in Times of Emergency, with conclusions and recommendations on human rights in times of emergency. The Committee on International Law and Sea Level Rise, with a resolution on impacts of sea level rise on maritime zones and their limits, maritime boundaries, and on statehood and the rights of affected populations. MOCOMILA, the Committee on International Monetary Law, with a resolution on the climate emergency and the financial sector. The Committee on the Rule of Law and International Investment Law, with a set of Athens practices and recommendations concerning the rule of law and investment law and investor-state dispute settlement. The Space Law Committee, with rules on non-orbital spaceflight activities. And the Study Group on International Law of Regional Organization, completing its work in Athens and with a formal resolution ending its mandate. All reports and draft resolutions are already available on the dedicated webpage of the ILA website. I apologize for any formal defects which could appear in the reports, and especially on the reports which arrived lately to us for the Committee on Submarine Cables and Pipelines and the Committee on the International Protection of Consumers. In addition, I wish to draw members' attention on the following new committees holding their first sessions in Athens. Those are the Committees on Business and Human Rights, the Committee on Comparative Diplomatic and Consular Immunities, Privileges and Inviolabilities, the Committee on Enforcing the Rights of Children in Migration, Committee on Protection of People at Sea, the Committee on Safeguarding Cultural Heritage in all stages of armed conflicts, and finally, the Committee on Urbanization and International Law. I shall also add that the two most recent committees, there are not 20 committees, there are 22 committee and study groups, and the newest committee on abuse of rights, the two co-chairs will be here to be networking and in touch, and the same for the study group on sexual and reproductive violence in conflict and post-conflict settings. I hope that members will pay particular attention to these sessions, as these new committees are open to new members and ready to start working. I wish warmly to thank the officers of all committees and study groups for the important amount of work, I should say the outstanding amount of work they have achieved to make the scientific part of this biennial conference a success. My thanks also go to our Greek colleagues who have organized this conference and have done really their best to accommodate the specific needs of committees and the study group. Special thanks are also due to all session reporters and to their chief, Thomas Ayon. I also wish to express my sincere gratitude to three people. The first one is, of course, Christine Schinking. I'm very touched by the words she had, the very kind words she had for me. Yesterday, Christine very gently asked me whether I was going to stay involved with the association. Of course, I will pay my membership to the French branch. I promise to do that. But also, I will keep. I discovered that Christine and I, we share a painful passion. We are members of a secluded club, the club of the supporters of former glorious football clubs. So it's an experience of suffering, but as you all know, the championships are done and the new championships have not begun. So this is the exact time of the year where Christine and I, we are happy, because we are not fearing the next match on Saturday and Sunday. So Christine, there is no chance that I will be grumpy this week. The second person is Antonios Tsanakopoulos, because he doesn't really know it, But my adventure with the ILA started in Greece, not in Athens, the summer before I was formally appointed Director of Studies. I knew I was going to be appointed, but I was not formally appointed. And I had some vacation in Tinos, a Greek island. And I was just trapped in a small beach where there was a small restaurant. I said trapped because you can't really escape from there. And one day I saw Antonios coming with a group of friends, and I was intimidated. He was very Greek, you know, with his group of friends, and he seemed very happy. And I didn't come to see him, but I think he remembers that time in Tinos and that restaurant I'm talking about. But he looked happy. And so I had this strange experience of saying, well, in a few weeks, I will be able to share drinks with that guy, and it has been a pleasure ever since. And my last thanks, of course, always, and it's close, always go to my very dear friend, Claire Martin, our Chief Operations Officer. We have worked so long, and we had so much fun. We really had fun, and this is what I will take from this. Chers et chers collègues et amis, vous me permettrez de terminer cette intervention en français, puisque c'est l'autre langue officielle de notre association, même si je vois les têtes qui tombent comme ça. Je quitte mes fonctions à la fin de cette conférence, n'ayant pas le don d'ubiquité. Je ne sais pas si je parviendrai à saluer l'ensemble des collègues et des amis qui m'ont accompagné durant ce mandat, et en particulier les présidents et les rapporteurs des comités et des groupes d'études. Et si je n'ai pas le temps de voir tout le monde, je vous prie de m'en excuser. Mais je suis très heureux de pouvoir accueillir à Athènes le futur directeur des études, le professeur Luca Lisinski, et de lui passer le relais vraiment en toute confiance. Notre association, plus de 150 ans après sa création, reste en mouvement. The association is still moving forward, et c'est à mes yeux une excellente nouvelle. Merci à tous.
Thank you so much, Pierre, and through you, thank you to all the members of the committees who have been working throughout and towards this conference, and who are actually here debating and discussing and ready to present themselves in all shapes and forms. In a few moments, the conference will start formally. We have the first meetings would actually be in this building, in the two amphitheaters. One of them is part of the parallel program. The other one is the product of the call of papers that we have done in an effort to make sure that our younger colleagues actually participate in the conference fully. The idea behind it was very, very clear. We did not really want to have a sort of new voices kind of process where there is, the formal procedure and there's something in parallel that somehow is different. We just decided to split all these presentations, so half of them come out of this call for papers and the other are there by invitation. We hope to have achieved this mixture between the older and more mature scholars and the younger, upcoming, brilliant new minds that join us in this conference. That would be the theme throughout. In parallel, we would have the meetings for all the committees who are going to be here, both closed and open. And you are very much invited to attend the open meetings and make sure that you participate in this feast of knowledge that ends up being the International Law Association. A few household issues. You have probably noticed young people wandering about with this blue blouse that says ILA conference. They're here to help you. So every time you are in need of assistance for whatever, you know where to turn yourselves to. We're trying to make this a paperless conference, but of course we all need papers. So you would see programs and paperwork scattered around, and our helpers would certainly have all the information you need at their own fingertips, and that means also your own fingertips. You're going to be receiving messages throughout the conference to your emails once you have registered, so that you know what is happening, when it's happening, and to be reminded of certain things. For instance, we have a tour of the Acropolis Museum later this evening, and immediately after that there's going to be a reception to the Lalaonis Museum, which is a jewelry shop thing, of amazing thing. I'm going to be stuck there, let me tell you that. And that will be directly next to the Acropolis Museum, under the Acropolis. So we hope to enjoy yourself throughout this week. It is going to be hard work, but it should also be fun. And this is certainly what we would like to achieve here. This is something that we have been talking about since the time when FEIPAS Argis organized the regional meeting in 2013. It's several years ago, but it is also our very great pleasure and privilege to have, for the first time in the 150 years of the organization, a full biennial meeting organized in Athens. So, without further ado, let the games begin. Thank you.